The Latin phrase "de Bene Esse" sits at the root of all recorded out-of-court testimony and its admissibility at trial. First applied in Roman law, the de Bene Esse concept was adopted into English common law and later into U.S. law. Dehame's Law Dictionary defines de Bene Esse as to take something for what it is worth, such as evidence collected for the time being, in the absence of, but in anticipation of, litigation admissibility to be determined when such thing is sought to be used against another in trial. In December A. Inc., BC Justice Boak said, "An examination de Bene Esse is an examination out of court and before trial of witnesses who are old, dangerously ill, or about to leave the country, on the terms that if the witnesses continue ill or absent, their evidence to be read at the trial. But if they recover or return, the evidence may be taken in the usual manner. In those instances, the witness is normally a willing witness." So you can see the origins restrict the practice of accepting recorded out-of-court testimony to instances of times where witnesses simply cannot attend court. In Canada, the practice remains this way most of the time, but it is up to the individual justices when to allow recorded out-of-court testimony into the court. In the United States, they have more liberally opened up the courts to using recorded out-of-court testimony, not only in lieu of witnesses able to attend court, but also to impeach in-court testimony if it differs from earlier deposition testimony. And what better way to bring that testimony into the court than on a certified video recording? To quote the late Gail Marquette, founder of the American Guild of Court Videographers, "The reason for the popularity of video recording of evidence in many cases is the impossibility of bringing the scene of the crime or the damages claimed in the lawsuit physically into the courtroom. The ease and low cost of video recording, the addition of audio, and the possibility of immediate projection make video recording the medium of choice in the modern courtroom." He goes on to say, "When it comes to depositions, the advantage of video is that it eliminates the high cost of bringing witnesses to the witness stand from remote locations during a trial and the opportunity of unrestricted time limits, in many states, on the examination of the witness. Because the witness is not intimidated by the formality of the courtroom, they are more liable to expand their answers, giving the deposing attorneys the answers for which they are looking." Further, video recorded out-of-court testimony allows attorneys to sift through hours of testimony to focus on the questions and answers most useful to be presented in court, saving the court's time and maximizing the impact of the case they are making. Out-of-court testimony has come a long way from what was once colloquially referred to as deathbed testimony. Certified legal video testimony, both in U.S. depositions and Canadian examinations, is a ubiquitous, powerful tool today, but it is interesting to look back to see how the concept of de Bene Esse was the root that brought video into our courtrooms today.